Hi, everyone. My name is Luke Boulet, and today I have with me Joanna Adams from Public Land Creatives.
Hi, Luke. Thanks for having me. I'm excited to do this with you.
Of course, yeah, thanks so much for being here. So today we're going to be talking about what is the Film Act and how do I abide by it. The Film Act was a really significant piece of legislation that standardizes photography and filming regulations across federal lands. So that's the National Park Service, U.S. Forest Service, Bureau of Land Management, and U.S. Fish and Wildlife. So historically, all of these federal lands had different enforcement mechanisms and different guidance for photographers and people wanting to capture film some of our nation's greatest treasures. And each of these agencies had different interpretations of the law, and then it even was not universal from park to park. So back in December of 2021, Joanna gave me a call and put on our radar this issue that was going on in Grand Teton National Park. But I'll leave her to explain some of the genesis of the issue and how that led to the creation of Public Land Creatives.
Sure. Yeah. So, in order to get to that point, we have to go back a little bit. We started actually noticing just the group of local photographers here. I live close to Glacier National Park, and we started noticing that there was some huge changes coming out. They were talking about, they weren't doing it yet, but they were talking about implementing a CUA program for portrait photographers, and a CUA program is really pushing you into a category of a guide where you're then required to pay like 3 to 5% of your gross income, have first aid training, even put like a logo on your vehicle. So it's very extensive in the requirements that they were going to be putting onto portrait photographers. So we noticed that. So we put together a group here and we rallied and wrote a letter, and we were able to get Glacier on a track that made a lot more sense in regards to permits. And then around that same time, a couple months later, we noticed that the Grand Tetons were rolling out a program, and they were full on, this is our CUA program, you got to jump on board or you're not going to be allowed to photograph anymore in the park. And that's when I got in contact with you guys. It was pretty extreme. Some of the measures were saying you couldn't even hike more than a half mile off the road. I think that one I was like, well, if you're trying to reduce the congestion and photography being in congested areas, why not let people hike in a couple miles to take pictures? So it was at that point that we realized this is not just a localized issue. This is a nationwide issue. And, talking to people that were very prominent in the photography community, there wasn't a group for centralized information, even just about photography permits and videography permits on public lands. So we're like, if we could have one area where people could get information, people could become members, and we could really be one voice in these issues, it would be very helpful. So that's how we started the nonprofit Public Land Creatives, and our sole mission is common sense policies for permits, both photography, videography, other creatives on public lands, and conserving the public lands for future generations. So that's how we kind of got into contact. And, we talked to many different people. Of course, we talked to you guys. We talked to lawyers. We basically just reached out to anybody we could reach out to and say, hey, what do we do? What's the situation here? And that's when we realized how difficult the law was that they were working with. And maybe you have a few things you want to add to that.
Yeah, absolutely. I mean, we worked also in tandem with the National Press Photographers Association and the American Society of Media Photographers. And they were, very helpful. I mean, each has their own different uh, uh, representative kind of sample, if you will, of members. In particular, NPPA. They're concerned a lot about usage of federal lands by journalists and First Amendment issues. So we had a really a great team that we sort of banded together with to target this specific issue. Um, but I'll let you take it back over, Joanna.
Yeah, so I think one of the things that we realized in looking at the law was it was actually signed into law under President Bill Clinton, which was like year 2000.
Hmm.
And this was before YouTube even existed. So it was a totally different dynamic of what people were doing in terms of photographing and videotaping on public lands. So what happened is they had this law that distinguished photography and videography as separate. So there were situations where you had to get a permit to take video, but you wouldn't have to get the permit to take photography.
Hmm.
Um, that part of it was very strange as cameras obviously developed and changed to where now you can take quality video with your cell phone. So that part of it was very archaic and not working well for people because there were photographers who were starting to add on like shorter videos to their packages. And it was very strange because then they had to go get the permit just for the video portion.
Hmm.
Um, the other part about the law that was really hard was the commercial, non-commercial distinction. This goes back once again to before we had social media and really the digital age that we have now. There was really two big groups. You have the big movie productions and then, the little people out taking pictures. But of course, all that changed and kind of morphed. So the commercial, non-commercial standards were really bizarre because you could take a video and put it on TikTok and happen to make money off of it. And the Park Service would tell you, well, you need to go back retroactively and obtain a permit for that. Super strange. The same thing with YouTube. If you were even a small YouTuber and you were making money, they wanted you to get a permit. Um, so it was around this same time when there actually was a lawsuit brought against the federal government for this gentleman who was videotaping a documentary on public land. I believe it was just two or three people, so very low impact, and he was fined. And the original court case said it sided with him. They said, yes, you are good to go. You shouldn't need a permit in that situation because the discrimination that was being put upon you was content related, whether you were commercial or non-commercial making money. So it kind of put the whole law really in this jeopardy situation of being like, well, the law is not really constitutional, is what the judge said in that court case. Unfortunately, that was pushed up to a higher court, and they determined that the current law was constitutional based on the fact that the process of taking pictures or video is not speech. It's simply like a step to get to the speech. Is a very kind of interesting way of looking at it. But I think that court case did help put this issue in front of people and say, okay, we have a problem. Like this
Hmm.
is not working for us, for the general people wanting to go take pictures and videotape. It also wasn't working for the Park Service, wasn't working for National Forest Service, because we would frequently get emails back from them where they were just confused. Like, we're trying our best here, but we don't really know how to interpret these various portions of the law. Another part of the law that was kind of funny was the definition of a model. So you were required to get a permit if you had a model, but traditionally they would say, well, a basic portrait session is not a model. But if you put on like a t-shirt for a company and you advertise on Instagram, like if you're an influencer, so put influencers in a really weird spot as well, because it was like, well, now you need a permit as an influencer, even if you've got like 1,000 followers and you're not some big shot making a bunch of money. So that was kind of the current law that we were looking at the time.
And for everyone, if you want to look back at the federal case, it was called Price v. Barr, and so there's a good bit of information about the nature of that case. One thing in particular is that this documentary videographer didn't actually intend to use it for a commercial purpose until years later, and so it was and this fine was issued. Years after the fact that the video had already been taken, and the law really left us in this very weird space where photographers and videographers were being put in the same category as like kayak rentals that exist solely in the park, and that's their only business, or hot dog vendors, or other such kind of like clearly defined commercial uses that have no real argument around like First Amendment protected privileges. Not to mention the fact that it can be argued that it was because of the photos taken by photography pioneers of John Muir and Ansel Adams that a lot of these federal lands exist. You have, I mean, Teddy Roosevelt was brought out to Yosemite by some of these pioneer photographers, and to show what, I mean, wonderful, what wonderful beauty our country has to offer, and the fact that they should be protected. So let's then dive into kind of how we got to the legislative process. So we were sort of diving down this path, and we reached out to the chairman at the time of the Senate Federal Lands Committee, or the Senate Committee on Federal Lands, and that was Senator John Barrasso, and the ranking member was Senator Manchin. At the same time, we also reached out to Representative Fulcher from Idaho, and it actually originated as a House bill, but Senator Barrasso was one of the legislators that actually reached out directly and called up the park himself. And I think it's really because of that phone call that the Grand Teton National Park ended up rescinding that CUA. But I mean, there was sort of a tandem effort between the House and the Senate that that the Film Act actually got passed. Representative Fulcher's issue was related to their public broadcasting service in Idaho, who was actually getting pushback from obtaining a permit to then film like a documentary, a free documentary for the public. And so that's in his words, he didn't want it to be quote unquote the king's land where the public didn't have access and usage of our federal lands for very non-impactful uses, which is virtually the same as any other person who's walking on the path and taking up the same sort of space at a scenic vista, or for example, Old Faithful, walking on the boardwalk to get access to that. So we got the legislation introduced in the House, and then it eventually made its way over to the Senate, and we ended up getting kind of two different bills throughout the legislative process, which kind of gets us to sort of where we are now, which is we have the Film Act in its current form. It is, PPA is very supportive of the bill, but I think Joanna will agree with me when I say that there are some minor tweaks that should be applied to ensure that this legislation is long lasting, and that it confines these federal agencies in sort of a box that can't be sort of overstepped in the future. And so there are some minor clarifications in the legislation that we are supportive of getting corrected. And this has actually been vocalized when the bill passed in the Senate. Essentially, it became sort of a running out of time issue, and that was referenced by Senator Manchin when he was on the floor. So it was really every intention to have this sort of minor tweak language applied, but just because of the way Washington works and the committee process and the way amendments are added to the bills, we ended up just kind of running out of time, and so we had to work with a older version of the bill, which is still much better than the current standard. And the most significant part was shifting the commercial distinction over to impact. And so now it doesn't matter whether or not you make a dime or $100. It's really whether or not you're making a measurable impact on the environment, and whether or not you're making a measurable impact on the people around you who are visiting the park just with their family. There are some people limits applied because we have to put a firm number on how many workers you could have in a certain area. And then the figures for those are, if you have less than 6 people, then a permit's not required. But under the current law, and we're trying to get this corrected, there's a de minimis use, which is 6 to 8 people, which you'd have to apply for an automatic permit. And then over 8 people, you'd have to apply for a permit in all those cases, 8 workers. So if you have a family of 10, this wouldn't apply to you. Joanna, do you want to talk about some of the things from the as passed bill and to what we're currently advocating for?
Yeah. So we really, when we started promoting this bill and thinking, okay, how do we want this to look? We had this great opportunity because in the past, whatever was passed in the year 2000, obviously we couldn't change that, go back in time, but it really got us thinking, what do we want a permit bill to look like for photography, videographers, like creatives in the future? And we really boiled it down to impact. Like, it shouldn't be content related, it shouldn't be commercial versus not non-commercial. And then figuring out, okay, how do we put those restrictions in so we don't have people coming in, destroying the land, causing a great impact, but we also don't have unnecessary permits for, like you were saying earlier, a family session or just a regular group of people coming in and enjoying the land like anybody else would. So we really, really worked hard on the bill language. And just like you referenced, there was a few things that we're still working on getting tweaked, specifically the 6 to 8 people for the de minimis use permit. There was a little bit more language in there too with the high traffic area
Mm-hmm.
that we wanted really clarified what exactly that meant, because we
Right.
didn't want to leave any room for, maybe an overly zealous government official to come in and say, okay, well, that means all these areas that people really like going to, you suddenly can't go to and take
Right.
photographs. The passage of the bill was actually super cool. So we weren't sure if it was going to make it through under the previous administration, just because it was getting towards the end, and we were pushing as hard as we could. And there was actually two fellows who were trying to hike. Well, they hiked to trail ran to the top of the Grand Teton and
Mhm.
documented that through video. And they were hoping to share that, put it into a documentary. And the Park Service there in the Grand Tetons again told them, we're not going to even issue you a permit. You can't even get a permit for that activity. It's legal activity, but we don't love it that you're promoting running up this mountain, not the safest experience or whatever. So there's actually a group called FIRE, and they really work on freedom of expression, freedom of speech, and they sued the federal government like one day before the bill got passed. So I do think that had a great effect in them being like, oh wow, okay, maybe we do need to push this through. So it was like a little bit of a Christmas present. We all, we pushed our members. We said, call them, email them. Even REI put out a thing like call, email. So I think they just finally felt the pressure, which was, as it should be, to get it pushed through very last minute under the previous administration. That's why a few of these changes we're still working on making sure get tweaked, so we don't have, so we have a solid bill that, like Luke said, can be for generations to come, and remove some of the complications that we have seen. So I was encouraged by the guidance put out by the National Park Service in reference to the bill. I don't know if you want to go over those points.
Yeah, sure. Thanks. So the National Park Service has thus far been the only agency, because even though the law is standardized across the federal agencies, each agency has to issue guidance to their federal workers and the public on how these laws are going to be enforced and implemented. So thus far, the National Park Service has been the only one to actually publicly release this guidance. They released it back in March of this year, and you can we're going to provide a link in the description below where you can access this and pull this up. But they referenced some key elements of the new law. You're able to bring in hand carryable, hand carried equipment only. So, that's you can bring a tripod, you could bring a light, but you can't use a vehicle to then besides like parking the parking lot. But you can't use like carts and stuff for bringing stuff on the path to then set up a whole kind of studio, if you will. So it has to be hand carryable equipment. It occurs in an area that's open to the public. You're not using exclusive use of a site or area. So, you're not stopping traffic. You're not saying, oh, you can't gather over here, members of the public. If you want to use a certain area of the park, then you have to apply for the permit. That's what gives you the reservation of that use or area. But as long as you're, not preventing anyone from, accessing a certain place, then you're going to be within compliance with this law. It does not adversely impact park resources, values, or other visitors, sort of what I just referenced, and is not likely to result in an additional administrative cost for the National Park Service. Essentially, saying they're not going to, require a ranger to kind of oversee the filming because it's in a sensitive kind of area, or like inside of inside, for example, one of the cliff dwellings at Mesa Verde. You're not going to be in there, and they don't want any damage to that, to any of those ancient ruins. They clarify that permits and fees are never required for filming, still photography, or audio recording that is associated with an activity or event that has been authorized already. So one issue that we dealt with in the past is Grand Teton was requiring two separate permits for a wedding. So one for the wedding itself, and then one for the filming or the photography of the wedding. So the Film Act got rid of that requirement. So now if you have a permit for the wedding, then you don't need an additional permit to take the photos. All the filming and still photography is treated under the same under the law. So there's a universal standard applied. So that eliminates kind of the arbitrary aspect of it, where if I take a photo, that's okay, but then if I turn my turret, one click and turn it to video, then suddenly that's going to be regulated firmly. Another aspect is that individuals and groups conducting film and photography are still required to pay entrance and use fees, just as everyone else. So this is just sort of a clarification that was applied, and those are really kind of the big things that were changed by the Film Act. Like I said, this link is going to be provided in the descriptions below, so you can access this at any time. And then when we get guidance from the National Forest Service, and then the Bureau of Land Management, and then U.S. Fish and Wildlife, we'll issue that when we get eyes on it. But thus far, we haven't seen any. And I will admit, it's been 4 months almost since the law passed, and 4 months for the federal agencies to issue guidance like this is kind of well within a kind of a reasonable standard. It doesn't mean it's right, but it's just kind of the way it goes. And especially with new administration coming in, and new sort of heads of agencies being placed, that's kind of the nature of things. Joanna, did you have anything else to add there?
Yeah, no, that's a great breakdown. I was excited to see the National Park Service put that out because, I was kind of nervous, like how are they going to interpret this? Are they going to come up with a different system that they try to kind of squeeze into this, but it was very true to really what the bill says and the intent of the law so far. So I'm happy about that. Um, I'm also anxious to see what the National Forest puts out, since we've had a lot of murky information coming out from them, especially in the
Mhm.
western part of the United States. So hopefully that provides some clarity for people. Um, but yeah, this is really exactly what, we wanted to see in terms of permits being based on impact, not content, not whether or not people like what you're doing on public lands or like your message, or something as silly as whether you're pushing a picture to take a or a button to take a picture versus a button to take a video. So
Yeah,
I'm excited about the future. I think it's going to be a great new regulations for people, and hopefully just clarify it, because that's the first thing we noticed when we started piecing together like the different areas and what was being done in one area versus another. It was just an hodgepodge of
hmm,
rules across even different national parks. One national park would say this, the next would say this, and the next would say this. And I'm like, you're all working under the same law.
yeah,
How are we coming up with these wild interpretations of it? So this is
absolutely,
really going to simplify it.
definitely. And thanks for mentioning that. Uh, one thing I just wanted to sort of address is that this does not allow photographers to to like fling glitter and leave it in the park. I just want to, not that that was message specifically, but there was kind of like this. Oh well, why are photographers wanting to eliminate regulations or modify the current way of doing things? Um, you know, like members of public land creatives and I know members of PPA, care, especially the ones that work on federal lands, care about them. They're usually in their own backyard, and they're there, I would venture to say, over 100 days out of the year. And we really cherish and value these places. So I think there was kind of a myth that was um, kind of being circulated that, well, photographers just don't care about the protection of these natural resources, and I that couldn't be further from the truth, because um, there's a whole reason why we want to capture these amazing places. It's that so we could show uh, the world it, and that we want to see it there for generations to come. I mean, these are huge economic drivers for some of these towns and um, all across America. I mean, I know Jackson Hole, for example, has a lot of tourism that is driven in from Yellowstone National Park and the other federal lands around there, which is your own backyard, Joanna. Um,
Yeah.
so
Yeah, we see so much of it here because I'm close to Glacier, and like in the summertime, that's when people really, the local businesses make their money because
yeah,
the tourists are here. So it's something we really do need to value. And one of the things that we kind of discovered as we started the process of, okay, how should the permits look, is some of the things that the National Park Service, National Forest Service were saying and were rightfully concerned about, like you're saying, the glitter being spread or people being in places that they're not supposed to be. Um, we encourage them, like, this is already illegal. It's already
right,
illegal to litter on public lands. It's already illegal to go places where they clearly have it marked, you cannot go here. You're destroying the flowers. It's not going to come back. So those are things where it's like, well, this would be an issue for even general members of the public to do, as
right,
it would be for photographers as well. And one of the big issues that we're working on is education for people. We have a lot of photographers from out of state that come here because we're close to Glacier National Park, and it's such a hot area for people to come visit. They come here to take pictures, and they don't always know where you're supposed to go, where you're not supposed to go, kind of the rules of the park. So one of the things we're working on is really educating people and saying, hey, if you're coming to Glacier, that's great. Here's some things you really do need to know about Glacier. Even things as simple as, I put out an educational post last year telling people, hey, don't, like, don't drown in Glacier. We lose so many people to drowning every single year. People don't even realize it. So just really trying to educate people on basic levels of, okay, this is what you should be doing. This is what you clearly shouldn't be doing, because not everybody knows that. We've had an influx of people visiting public lands really since COVID. It just got insane. So some of those people just aren't educated and don't know. So that's one of the main missions of our nonprofit as well, is educating people and saying, hey, we care about the environment. We care about preserving these places for future generations, and behave yourself so that you don't get booted out.
Yeah.
So that's been a big, like a little bit of a shift in the mentality as well. Because you're right, people were initially concerned, saying, well, we can't have people just trashing these areas, which we completely agree we can't have happening.
Yeah. 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 Thanks for referencing that. Really, I think everyone agrees that the protection of these federal these areas of majesty, to coin a phrase, but that we want them preserved for generations to come. So now, kind of the pathway forward is PPA is there, every month on Capitol Hill, pushing for this corrected version of the Film Act. We're also up there for other things such as copyright modernization and artificial intelligence, and advocating for specific regulations that will be sensitive to copyright holders and the usage of copyrights. But film is something that is a topic of conversation for every month that we're there. So we're actively engaged on this. We'll be putting out a video talking specifically on the areas of advocacy in July, and so that will be for public viewing, for everyone to see. In that month, it's going to be part of our benefit of the month focus. So stand by for when a new bill comes down the pike for the modification of the Film Act. We're hoping to get it passed in this new Congress, the 119th Congress. And then, I'm sure, Joanna is going to be, actively engaged with us in that fight as well. If there are, especially if there are issues that arise for specific people engaging with these various federal agencies. But we're very hopeful that with this new guidance, that it's going to mitigate a lot of the issues that we experienced in previous years when advocating for this issue. And I just wanted to say that the fact that we started really on this issue back in the later half of 2021 and got it passed in 2024 in December is remarkable, and is really lightning speed for how Congress and the bill making process goes. And so it was really through bipartisan advocacy and the grassroots and people like you engaging and then giving testimonials about specific instances that you've dealt with, various rangers or other federal workers, and kind of the problems that you met with them. So it's all through people watching this video right now that we were able to achieve that significant piece of legislation. So I just want to thank Joanna and all of her members and PPA members and the members from National Press Photographers Association and the American Society of Media Photographers that we actually got this passed. So it was really a unification of many organizations, as well as Congress, through Republicans and Democrats, that this actually was passed, and that this game-changing legislation was achieved.
Yeah, I agree. It's, you think one person, it's hard for one person to make a difference, but if you can have a group of people who are all saying, all with the same message, which I think was super powerful, because we had PPA and all these other nonprofits, we had ourselves, and we had so much bipartisan support from both sides of the aisle that it was kind of a no-brainer. It's like,
Yeah.
Why not fix the problem we're having here? So it was really cool to see actually everybody come together. and agree on, some fundamental points that I think are really important to this country and to the public lands and to the ability to be able to share your experiences on the public lands, I think is so important and so cool. And, I really appreciate the group of people that we have because they work tirelessly to make this happen. And our members are amazing because they said, like, we'll put out a post and we'll say, hey, who's experiencing this? What are you experiencing in this area? And I'll have emails come in and messages come in. And that's really good to get the broad story of what's happening. That way it's not just, one person that's having a problem, but you really see, okay, this is a real issue that many people are experiencing, and how can we tackle it as a group? And that's been super powerful. So it's been an amazing experience. It's been super cool. The fight's not over yet. I'm sure we're going to
No,
have, it's going to be an ongoing battle, but I'm very excited for this really huge win for everybody.
me too. Me too. So that summarizes the podcast for today, folks. I want to thank you all for joining us. Thanks so much, Joanna, and her folks at Public Land Creatives for helping us out in this fight. And I just want to thank you all for joining us today. We look forward to engaging more on this legislation in the future and communicating that to all of you. So. Thank you very much. I hope to see you again in the future, and I wish you all the very best.